tuning in, logging on, and just hanging out with me and my special guests today. Um, we have a great show with Jesse Witten and Steve Lokensgard of Faegre and Drinker. And they told me if I got the name wrong, they were going to storm out on me. So I tried to, while it was fresh on my mind, make sure that I got that out there. Uh, as always, like I said, I'm so appreciative to each and every single one of you that is joining our podcast today. I think we have a great show. And while we were planning on specifically focusing on and talking through the 60-day rule, as Jesse and Steve and I were getting ready to go live here, we started engaging in some different conversations. And I want to kind of take us down that road in just a little while. So, anyways, gentlemen, welcome to the podcast. Thank you so much for taking time out of your very busy schedule and spending time with me and some of our guests who are live streaming with us.
Our pleasure. Thank you for having us.
And I tried to convince Steve not to wear a suit, but he told me that's just the way he rolls and to deal with it. So we're going to deal with it. So look, the reason why I asked these two gentlemen on to the program, one, because they specialize in healthcare. They are centric to that is centric to what they do, but they co-authored an article together not too long ago, and it was a feature article, and it was based on the 60-day rule. And they asked the question, does the 60-day rule apply to overpayments that providers receive from Medicare Advantage and Medicaid managed care plans? Before we really dive straight into the MCOs and MAOs, I thought it would be prudent for us to take a stroll down memory lane, if you would. And let's really talk about the 60-day rule under the Affordable Care Act, under ACA. Excuse me. And let's talk about where this all stems from. So, Steve, if you can take us through a little bit of the history of the 60-day rule, I think those tuning in with us would be appreciative of that.
Yeah, great. Well, thanks for having us, Sean. This is a lot of fun to try out this format. And, since you invited us, we've looked at the podcast, and now I think it's a regular, in my podcast lineup now to tune into the compliance guys. So thanks again for having us. So when we were talking about kind of setting the table for this issue, we were talking about the fact that, 20 years ago when compliance was kind of at its infancy, right? I mean, HCCA just had their 25th annual conference, right? So, I mean, this whole area of healthcare compliance is still relatively, young. And when you think back about 20 years ago, if you did some sort of a compliance audit in the early days of compliance and you identified a potential issue, there was this legitimate question, do we have a duty to repay overpayments? And, what do we do? And generally, if you found a claim that you billed in error, you would pay back that claim. But, what sort of duty did you have to look deeper into a potential issue? Like if you had a really high error rate, did you have to go further and investigate? Or, could you kind of put your head in the sand? And kind of there was a real debate at the time. If you ask federal prosecutors or the OIG, they'd probably say, yeah, you have a duty to look into that a little bit deeper and investigate and repay whatever you come up with. But attorneys tended to give advice that, well, it doesn't implicate the False Claims Act unless you take some affirmative step to conceal that overpayment from the federal government. And so, there was just a difference of opinion prior to the Affordable Care Act. And in 2010, Congress passed among this, we still have the two books summarizing the Affordable Care Act, just an awful lot of healthcare enforcement rules coming out of the Affordable Care Act. But one of them was the 60-day repayment rule. And it kind of, clearly took the position that if you have identified an overpayment, you have a duty to refund and repay that overpayment within 60 days. And so that kind of settled the argument that if you failed to refund and repay that argument, it could implicate the False Claims Act. But there were still a couple of issues that weren't crystal clear in that statute. One was the look back period. How far back did you have to look? You had a duty to exercise reasonable diligence in identifying overpayments if you think that there's a problem. But how far did you have to look back? So that was one issue. I think the temporary rule, the draft rule suggested that it was a 10-year look back. And when the final rule came out, it was a 6-year look back. So it resolved that question.
Yep. And so while we're talking about this, one of the questions that always comes up, right, is it's the 60-day rule. Does that mean I only have 60 days in which to issue a refund? Because in order for us, look, if somebody from my billing office calls me and says, we have an overpayment and we owe $100,000. I'm not the type of person that's just going to say, oh, Eric from the billing office told me we owe $100,000. Let's just go ahead and write a check. One, I'm not sure how many practices can just go ahead at this point right now after coming through a pandemic the way that we have, and stroke a check for $100,000. But more importantly, don't we have to do a bona fide investigation to be able to not only identify that there is an overpayment, but to actually confirm it, right?
Yeah. So exactly. That was the second issue that wasn't entirely clear from the statute. And then some case law came about after the statute was effective, and regulation later clarified this, that the 60-day clock doesn't start until you've identified the claims that need to be refunded and you're ready to push that button to click send. Then, at that point, once you've vetted this, and, Sean, we talked a little bit about this, I think in general, you would say you have to exercise reasonable diligence, but they expect these kinds of investigations to be completed generally within 6 months. So you've got some time to figure this out. And then, when you work with the client, the legal folks are just one set of eyes on it. It's the compliance folks, the revenue cycle management folks, the operations folks. They've all got to look at this and agree that there's an overpayment. And yes, those are the claims that need to be refunded. And then you've got 60 days. And
that's the hard part, right? Because there's so much subjectivity when it comes to, is something, a level 4 or is it a level 3? Is it a level 5 or is it a level 4? Was this a high complexity admission or was it a moderate level of complexity? I tell people all the time, you could take one chart note and give it to 10 coders and you could wind up with 9 different opinions on this thing. That's how subjective these things can actually be. So, I think to kind of tie that together, you're saying, again, people need to use reasonable diligence, but reasonable diligence means that the government expects for a bona fide investigation, a practice could have up to 6 months to be able to conduct a thorough investigation, to leave no stone unturned, and to arrive at the conclusion of, yes, we have confirmed an overpayment. So once we have confirmed that, after, let's just say, we take the full 6 months, we have up to 60 days at that point then to issue that refund or to make that disclosure if we decide to go that route. And I'm holding off on the SDPs right now, the self-disclosure protocols, because we are talking about Medicare's 60-day rule. So that would be under the voluntary refund, correct?
Mm-hmm. Yeah, and so I think those were the kind of the two main bread and butter issues that weren't clear when the statute was passed and were clarified when, you know, the rule was promulgated and finalized in 2016. And then we knew for at least Part A and Part B, you know, kind of what the rule required and what the definition was of discovery and the look back period. So that answered most of the questions, but I think now with you know, the continued growth of these managed care plans, both in the Medicare space and certainly the Medicaid space, it's huge. The question that Jesse and I have been getting a lot lately is, you know, do we have to include those claims in our investigation?
Yeah, and I think, you know, obviously I get that question a lot from our clients. I actually have different attorneys that have reached out to me that, you know, say, hey, you know, my client is wondering and I'm not really sure of the answer because there's really no definitive answer at this point as far as they're able to find. So that led me to, and again, I want to give Robert Lyles, who's one of my great friends, I want to give him a ton of credit because he introduced me to Jesse and Steve through this article. And I started looking at it because Robert and I had a discussion about it not too long ago. And the question was, well, do we need to look at Medicare Advantage? Do we need to look at Medicaid? You know, these MCOs. And we, you know, we landed on maybe we should just play it safe. And let's go ahead and take a look at these as well and include these as part of all federal payers, not included in Medicare Part A or Part B, but a federal payer plan. Now, after reading your article, it raised a significant level of doubt for me as to whether or not I should have done that. But again, I was trying to be conservative in my approach to that. So, Jesse, you and Steve embarked on writing this article, and you cited what I think is really an interesting case in here, which is United States v. Walgreens. But you really take some interesting positions on this. Can you start to kind of walk us through and help us, you know, our viewers, our listeners, to understand how you arrived at some of the opinions that you came up with on whether or not these MCOs and MAOs are tied to the 60-day rule?
Sure. Thanks, Sean. The article that that you're talking about, Sean, was published in the American Health Lawyers Association monthly magazine called Connections. And Steve and I tackled the question that you raised at the outset. Does the 60-day rule apply to overpayments that a healthcare provider gets from Medicare Advantage or Medicaid managed care plan? I've been asked this question multiple times by clients over the years, and I've given answers. And Steve separately has been asked that very same question. Steve and I were with different law firms that merged 2 years ago. So we found each other a couple of years ago and discovered that we've separately been dealing with the same question for the past decade. And I was like, you know, screw it. I want to get to the bottom of this issue once and for all. And we really did comprehensive research, legal research and analysis, and found, first of all, that there's nothing out there written about this virtually. We found maybe one stray line in a law firm client alert, and then something else that was, you know, not comprehensive. So we really undertook to do comprehensive research in thinking about this. And the conclusion that we've reached is that the better of the legal argument is actually that the 60-day rule does not apply to Medicare Advantage overpayments paid to a provider or overpayments received by a provider from Medicaid managed care. And it's really tied to the language of the law. And one of the key things, you know, our article is long and boring and legalistic, but one of the key points is that the 60-day rule says that persons have to refund overpayments, and then it defines what a person is, and it includes specifically Medicare Advantage organizations and Medicaid managed care organizations. And then separately, the law says who you have to give notice of the overpayments to. And it lists intermediaries, and it lists carriers, and it lists the state, and it lists lists who it lists, but it does not include Medicare Advantage, and it does not include Medicaid managed care. And then if you go deeper and deeper, all the language of the statute lined up to support, I think, the conclusion. Now, we try to include in our article the counter arguments, and there are always going to be counter arguments. So the narrow question is, does the 60-day rule apply to these overpayments? I don't think it does. It clearly applies to overpayments that a Medicare Advantage organization itself gets from Medicare, or that the Medicaid, managed care organization, Aetna or Cigna, whoever is the insurer, overpayments that it gets from the state, but it does not, so far as I can tell, so far as we've researched, apply to the overpayments that the provider gets from the insurer. Now I need to interrupt myself and you,
No.
and say that the United States government apparently does not agree with me, because the Department
Go figure.
of Justice, how about that? The Department of Justice has filed False Claims Act cases, including the one that you mentioned involving Walgreen, in which the government does take the position that the 60-day rule applies to overpayments from Medicare Advantage or from the Medicaid managed care. This issue has not yet been tested really in the courts, but I think there's a very a more than sound defense. We've wrote a whole article about it, but I hasten to add that the United States government disagrees with Steve and me.
Sure, and that's no big surprise. And I'll share with you some interesting. We'll have some interesting conversations a little bit down the road. But one of the things that you actually talk about right out of the gate is the fact that the government actually relied on the reverse false claims provision of the False Claims Act, right? So rather than me trying to go through and bungle, which I hope I wouldn't, but rather than me trying to go through and explain the difference between the False Claims Act and a reverse False Claims Act, which is tied to the FCA, can you gentlemen explain what the reverse False Claims Act is and why that's so important?
Sure, I'll bungle that instead of you, Sean. The straightforward provisions, let's call them, of the False Claims Act say that you can be liable if you submit a false or fraudulent claim to the government, and the way claim is interpreted, the way claim is defined, it even includes the government contractor. So it probably, in fact, would include Medicare Advantage organizations. So there's a direct false claim provision, which barely needs explanation. It does what everybody knows it is. The reverse false claim provision says that you can also be liable under the False Claims Act for various things, including failing to refund a known overpayment owed to the government. And mind you, this is not limited to healthcare. If you're a defense contractor and you owe the Pentagon money, the Reverse False Claim Act would apply. That overpayment is an obligation. That's the word that the statute uses. So the way the 60-day rule fits in is what the 60-day rule technically does is it provides an expanded definition of the word obligation. And it says that the failure to refund a known overpayment within 60 days of identification to Medicare or Medicaid it qualifies as an obligation. So the 60-day rule plugs us into the reverse false claim provision of the False Claims Act, which, like I said, imposes liability on failing to refund a known overpayment owed to the government.
And as part of the Reverse False Claims Act, is it also true that a prosecutor is also looking at what was the frame of mind of the individual who was submitting the claims at the time they submitted the claims, right? So talking about intent. Now, I understand that they always talk about there has to be intent, and the provisions in the law actually say there doesn't have to be intent. The government just has to show that claims were submitted that contained bad information. Is that, am I close.
I'd say you're close. um, Under the reverse false claim, you might be completely blameless in having caused the overpayment, and you might not. You may have zero responsibility for the overpayment. It may be entirely the government's fault, and you didn't even know it at first. But once you realize that you have that overpayment, then you are subject to reverse false claims liability. So there is an intent requirement in the intent of not refunding, and there's maybe some gray area about just whether that can be reckless disregard of your duty to refund or actual intent. But it's clear you don't have to be. You can be completely blameless in having caused the overpayment in the first instance.
Got it. So we've talked a lot about the application of the statutory duty to refund and to report these overpayments, right? And that's really what we've been talking about thus far. And I think that's what your article really paints such a clear picture for the reader to be able to follow. But you shift into the CMS regulations for Medicare Advantage. Can we talk about some of the Medicare Advantage regulations? And then from there, I want to talk about some of the Medicaid managed care as well.
I'm happy to start kicking off that conversation, and I think it's easiest to talk about them at the same time, Sean, and
Okay.
compare and contrast, because the Medicare Advantage rule came out in 2014, and it clearly required Medicare Advantage plans to refund and repay overpayments to the federal government within 60 days, and it clearly incorporated that 60-day rule. But it was really silent on the duty of providers to refund and repay overpayments to managed care plans. Contrast that with the Medicaid managed care final rule in 2016 that didn't necessarily place a clear direct duty on providers to refund and repay overpayments, but it did require Medicaid managed care organizations to include in their contracts with providers the obligation to refund and repay overpayments within 60 days. So it said contractually you have to require that in your contracts with providers, and you have to establish a mechanism for receiving those overpayments. But you know, the Medicaid managed care plans don't actually have to return those overpayments to the state Medicaid agency. They can keep those overpayments. The kind of overpayments that a Medicaid managed care organization might actually have to refund would be some, you know, calculational errors with, you know, what they would otherwise be entitled to under the contract, but not these specific overpayments from providers. So that at least gives you a little bit more of a hook if you're a prosecutor to say, well, you know, contractually you're required to require providers to refund and repay. And so is that kind of an indirect, you know, obligation through this regulation? But there's nothing direct in the regulation requiring providers to refund and repay those overpayments.
Got it. Go ahead, Jesse, please.
Yeah, so Steve's, you know, this is a huge point. Our article focuses on the False Claims Act, the 60-day rule. Violating the 60-day rule leads to False Claims Act liability, potentially civil money penalties, potentially exclusion from programs. That's all that's what we analyzed. But there could be a contractual duty with your insurance company, the Medicare Advantage organization, or the Medicaid managed care, like Steve just said. If the Medicaid managed care organizations are following their rules, they will have inserted into their contracts a refunding requirement if there's an overpayment. And, you know, so at the outset, Sean, you said, was I being too conservative? I can't say that you were. There's, I also, there may be state laws as well and contractual duties, as we just said. And, a provider usually hopes to have something of a long-term business relationship with their insurance company. And that's something that this overpayment is part of, dealing with it as part of a bigger, broader business relationship. And, and I haven't even begun to talk about the ethical issues, which I don't have a license in ethics. I only have a license in law. So, the worst that can happen to you is False Claims Act, civil penalties, exclusion. And that's what we first and foremost most focused on. A relator, whistleblower, can't file a key tam lawsuit alleging a breach of contract. That probably is not good enough. It really has.
Right. Yeah, I'm with you. So on this part of the discussion, to kind of use your words in your conclusion, what you basically stated is, for all the reasons that you have cited over the last 27 minutes that we've been at this, the most straightforward interpretation of the False Claims Act and the 60-day rule is that those statutes do not apply to overpayments received by healthcare providers from Medicare Advantage or Medicaid managed care plans. But in litigation, however, the government has the ability to allege that there's a failure or a duty that you have failed to comply with to issue that refund within the parameters of ACA's 60-day rule. Is that a fair conclusion statement?
It is. I mean, the government can allege that, and I hope that somebody forces the issue and we get a real resolution. If the government alleges that, I don't think for all the reasons I've already laid out, that Steve and I have laid out, we think the government should lose. But
so basically, Steve's laughing because I'm starting to laugh. So basically, what the three of us are sitting here and actually saying is that we hope somebody is put to the test by being accused by the federal government of violation of the False Claims Act, and they decide, you know what, we're going to challenge this. There's no case law. We don't know how we're going to make out in this thing, but we'll see you in court. And I think that's what the three of us are kind of sitting here hoping to see, because for us, that would kind of be like, a playoff game, in the NFL, right? Or in MLB. I mean, I'd have my popcorn ready. I'd be sitting there. Actually, my wife doesn't let me have popcorn anymore. She makes me eat these 70-calorie fiber bars because apparently I'm getting old. So,
but Steve, I know you're a big rule of law kind of guy. It is just ridiculous that the Affordable Care Act was passed 12 years ago, and we're sitting around for the past 30 minutes on a very entertaining podcast asking a question that Congress should have told us from the outset. It's really an absolute utter failure in government that the regulated community doesn't know what laws apply to them. It's really it kind of makes your blood boil if you.
Well, it's infuriating. There's no doubt about that. But I don't know if I should be thrilled with the fact that you said entertaining versus informative, but I'll take whatever adjectives I can get these days from our guests. But no, I agree with you. And Steve, please go ahead. Take that further if there's more that you want to say on that. But I agree. I think it's absolutely atrocious. But I also wonder if that's not part of the choreography on the part of the government to leave things so gray that during a deferred prosecution agreement, during a settlement agreement, during a process by which they may bring an indictment against an individual or a group, that they don't have these other things that they could throw like a bowl of pasta against the wall to see what sticks.
Well, certainly when you're at that stage, you're going to raise every argument possible. But the difficult thing for us compliance folks is, we're at the front end of this, and we've identified an issue, and we're wondering if we need to, in our retrospective investigation of this issue, if we need to include Medicare Advantage claims. And so I think it comes down to that difficult risk issue. Like I always say, like litigators like Jesse, they're the smartest people in the room because they come in and say, how could you have messed this up? But us compliance folks are at the front end of it and trying not to mess it up, trying to get it right from the start. And so, the article that was published in the ALA magazine had some word, number of word limitations. And so we couldn't get into some examples to kind of play it out. And it might be kind of a risk assessment that you have to undertake. But giving a couple of examples from a compliance perspective, let's say that you have an issue that you've clearly violated the anti-markup rule or the 3-day payment window rule. Those
Right.
kind of bread and butter compliance billing issues. Well, you don't include Medicare Advantage claims in those because those plans don't follow those rules. Those are unique Medicare fee-for-service rules. So it's kind of easy to rule that out. Even if you've gotten those wrong, it's not going to trigger an overpayment, let alone a False Claims Act issue. So, from the start, you can rule out Medicare Advantage claims on those issues. But let's get into a little bit more difficult issue. Say you've got a real problem with inflated diagnosis codes, and you've done some auditing and you've discovered that you are I don't know how we got this so wrong, but our diagnosis codes are inflated from what they should be. Well, that's a more difficult issue because that really has nothing to do with your billing from Medicare fee-for-service. But on the Medicare Advantage plan, they're getting reimbursed more from the federal government the higher those, the risk scores are on those individual patients. And so if they're inflated, then the Medicare Advantage plan is getting an inflated amount. And if you, the provider, have some sort of a value-based or risk-based deal in place with that Medicare Advantage plan, then the amount you're receiving is higher than it should have been as well. And so in a case like that, that's the Sutter Health case, and that's where the district court said that this could possibly be a False Claims Act case for submitting claims with inflated diagnosis codes and not doing anything about it.
Yeah. And you raise a great point, right? Because everybody is so focused on looking at evaluation and management services, or they're so focused on looking at, in-office procedures or those done in an ASC or in a hospital. But the truth is, you got to be equally as concerned with your diagnosis coding, because, as I try to explain to folks who are coming into the industry, and we're seeing a huge influx, as we have for the last decade, of new people coming into the industry, providers on, folks on the business side, our outsourced folks that are over in India or Pakistan or in the Caribbean. I try to explain to folks that, look, a CPT code is nothing more than 5 numerical digits that has a fee attached to it because you were able to describe what the service was to an insurance company. What determines the medical necessity of those services is the diagnosis code, because the diagnosis code tells us why we did it. And to your point, that's why there's all these HCC audits that are taking place to make a determination as to whether or not your reimbursements, and in the case for the payers, whether or not for the amount of work that's included in taking care of patients at these higher levels, whether or not the compensation is correct. So, if you're using, to your point, Stephen, these overinflated diagnoses and you don't have the documentation to be able to support the use of those, we find ourselves in a more complex situation now where, because of the diagnosis coding, we're potentially in an overpayment situation. I think that's where you were going with that.
Yeah, I think the diagnosis code issue is an example of, I think a higher risk. If you know you have a problem with diagnosis codes and you don't go back and exercise reasonable diligence to identify the scope of this issue and then, correct those with the plan, both you and the plan could be in trouble for submitting those, claims. And so, that's a risk issue. We'd love to see it litigated. And, it has, in fact, been litigated in the Sutter Health case, but they didn't really, the court didn't have any real specific findings about the applicability of the 60-day rule to claims submitted to a Medicare Advantage plan.
While we have some time, so I think you gentlemen wrote an incredible article. I followed it on LinkedIn after I had posted about it, and some I think you all posted your article as well, and there were just a lot of great comments that were coming from people that really sparked an outstanding conversation and got people really thinking about this. But one of the other things that we use, and I think this is a tie-in, and if you're okay with that, I kind of want to go this route maybe in the last little bit that we have together. When we're talking about making a determination as to whether or not an overpayment exists, a lot of times practices, compliance officers, auditors, coders, they're relying on local coverage determinations, okay, LCDs. And I've heard both sides of the street on this. I've heard practice managers tell their physicians and others in the group, this is the law. This is the law. You have to comply with it, because if you don't, you're in big trouble. I've had others who have said, well, the fact of the matter is, Sean, it's really a de facto guidance, because you can't say something is the law without promulgating it first and having it go through a formal rulemaking process where there's an open comment period, etc. So can we talk a little bit in the time that we have left together about the applicability of the local coverage determinations? And, Jesse, you brought up a fascinating situation with the general counsel of HHS. I think he's a former general counsel of HHS now, back in 2020, and his opinion, his legal opinion on LCDs.
Yeah, sure, Sean. We were talking about this just before we went live. You were talking about a situation you have on your hands with LCDs. It's funny, this is a second issue that I just have stumbled on repeatedly over the years, which is what is the legal effect of a local coverage determination. And for when it comes to medical necessity, unless there happens to be something more specific in the law or in a true CMS regulation, the default rule is that there's Medicare coverage if the service or item that's provided is reasonable and necessary. That's what the statute says. So, and that's obviously a little bit in the eye of the beholder. It's not it's not black and white necessarily.
That's right.
But so a local coverage determination might get it right. It might be what a judge says is reasonable and necessary. And the people promulgating it know a thing or two about, healthcare. But in and of itself, the local coverage determination has no effect of law. That's what I have concluded over the years, for precisely the reason that you gave, Sean, which is that it's just a declaration by a government contractor. It has not been issued with notice and comment rulemaking. By contrast, a national coverage determination, which gets generated out of Baltimore, out of CMS, does go through the formal publishing and comment process, and it does have a higher pedigree in terms of being a source of law. But the local coverage determination does not. And what you're referring to, Sean, and I wish I remembered his name, but I don't. But the general counsel at the end of 2020 wrote a memo in which he described how the Supreme Court decision in a case called Alina would be applied. Alina basically said, following the Weiss doctrine, that that a document that hasn't been promulgated properly according to the Administrative Procedures Act with notice and comment has no force and effect of law, and a violation of it is not a violation of a law. And the HHS General Counsel endorsed that view or applied that view to the Supreme Court's view, so he has to accept it. But he specifically said that that applies to local coverage determinations, and that you cannot support a law enforcement activity like False Claims Act solely on a local coverage determination. It's got to be on the reasonable and necessary standard.
Right. And you know, that's one, and that's such a great explanation. Thank you, Jesse. You know, that's why one of the things that I always ask of a client when we're talking about specific claims and we're preparing either for an administrative law judge hearing or we're preparing for a civil trial or a criminal trial, you know, I always ask them, is this service in hindsight? Because, you know, a lot of times you talk to a physician and they say, you know, in hindsight, I could have done a better job of documenting this, or I should have said that. But what I always ask them is forget about the documentation aspect of that, right? Because the documentation in a physician's record originally was so that if a physician or another provider had to assume the care of a patient, they could do so in a safe and prudent manner, right? Over the last couple of decades now, the medical record really became a method for insurance companies to say, gotcha.
Right.
This is my opportunity because you didn't count all the beans in the history or you didn't count all the beans in the examination. And, you know, so I always ask them 3 questions. 1, do you as a clinician believe that the service was reasonable? 2, do you believe that was appropriate for the presenting problems or the conditions that the patient has? And 3, was it medically necessary? And when I talk about medical necessity, I talk about medical necessity from a generally accepted standards position, right? What is a generally accepted standard in the medical community? Has it been peer reviewed? If we're doing something for off-label purposes, is there enough clinical data on this to be able to substantiate the reasons why we're doing this? So to your point, forget about the local, and I shouldn't say that. Don't forget about the local coverage determination because that's what all the MACs are going to cite, and that's what the, you know, the QICs, if you're involved in an appeal, the qualified independent contractors level 2, your redetermination, they're going to speak to specific LCDs. But to Jesse's point, if these are not promulgated in the law, then it's a de facto guideline. It's no different in a sense than saying, well, the American Medical Association CPT manual says, well, nobody submits claims to the AMA for reimbursement. So that's guidance. I think what you're saying is anything that's not been promulgated in the law is de facto guidance, and you have to revert to what is medically reasonable, medically appropriate, and medically necessary in order to be able to substantiate your claim. Is that fair?
Yes, I agree with what you said. I would like to add, though, that
Please.
if you're not following the LCD and you're audited or worse, you're going to have some explaining to do.
Right.
Because the LCD didn't emerge out of nowhere. There's usually some reason that it was promulgated, and so but there can be explanations. I don't mean to say there can't be, but you will have to do some explaining to do. And the second thing is, here again, you know, the Department of Justice has settled False Claims Act cases, has intervened in False Claims Act cases brought by relators that were premised on violating an LCD. The government just collapsed the LCD as equivalent to the reasonable and necessary standard. It isn't quite that simple, like we just said, but right. You know, we do have to. I mean, it bears knowing what the government has done in its enforcement history.
Excellent, excellent. Stephen, anything else you want to add?
Yeah, no, I totally agree. Just from a compliance perspective, of course, we want to design a system to ensure compliance with the local coverage determination, just to prevent overpayments. Even if we can make an argument down the road that it doesn't implicate the False Claims Act, you still don't want to be subject to some sort of a, significant overpayment for failing to comply with the LCD.
Absolutely. Absolutely. All right. So I think we have beaten this horse into the ground with respect to the 60-day rule. What I would say is I think all of our listeners, all of the viewers of the podcast, the live stream, folks who have read your article from the American Health Law Association, I think a follow-up article where you can expound upon some of the things that you didn't get an opportunity to do in that first article, which was fantastic. And if you all have not read it, I will make sure that I reshare my original post that had this article in it. Again, the article is written, co-authored by Jesse Witten and Stephen Lokensgard, and it's does the 60-day rule apply to overpayments that providers receive from Medicare Advantage and Medicaid managed care plans? If you're not a member of the American Health Law Association, don't worry about it. I'll make sure that we find a way to put this in your hands as long as I don't violate any copyright from AHLA. Because again, that's a group of lawyers. So, so Jesse, Steve, I can't tell you how much it means to me that y'all were willing to take a chance and come on to this program with me. I hope that we've been able to get the message out there to at least help other attorneys, help other compliance professionals, and to help others who are going through a questionable situation right now in trying to figure out whether or not they include Medicare and Medicaid managed care as part of their overpayments under the 60-day rule. I think you've given them a lot of food for thought. I've made sure prior to our podcast today that I've linked directly to your law firm. I got it right one time. I'm not going to press my luck and try to say it again. So I'll just say the link is in the post. To again, each and every single one of our listeners and viewers, I can't tell you how much it means to me that you're willing to take time out of your busy schedules to tune in, log on, and just hang out with me and our special guests each week. This week is a little bit different because you heard Steve earlier talk about the 25th annual HCCA conference. The 26th annual conference is coming up next week in Phoenix, Arizona. Yours truly is honored and privileged to be able to present in Phoenix next week on Wednesday, the 30th at 12:15, session 708, building an effective risk-based audit program. So those of you that are going to be out there in Phoenix, I hope that you'll consider joining in my session. The rest of this week, we have the one, the only Christine Hall, who will be joining the program live tomorrow. And then we'll finish out the week with Robert Lyles and Paul Weidenfeld of Lyles Parker. And we'll be talking about exclusion screening, but also talking about OIG exclusion. And what does that mean to each of you as a healthcare professional and as what the law refers to, an entity working in this industry? So again, on behalf of myself and the entire The Compliance Guy crew back in Knoxville, I want to say thank you again for hanging out with us for a little while today. Remember, be good to yourself, but more importantly, be good to each other. And until tomorrow, have a great day.